Let's bring in our legal experts to break this all down. Criminal defense attorney Eric Puryear and national trial attorney Michael Jaafar with us. Michael, your take on what we're hearing inside of the courtroom and the tolling versus concealment. There's this question about whether the statute of limitations was properly tolled. Can you break that down for us?
Yeah, this judge would be wrong if he thinks that the statute of limitations was tolled in this case or in any murder case. Tolling does not apply in murder cases. It's a single event case. Tolling, it's black letter law that tolling applies to statute of limitations when it factually matters. So an example would be somebody commits fraud, and then when they commit fraud, few years later they want to conceal that fraud further by taking a certain asset and moving it. Now they've basically revived the crime. They've brought it back to life. You can't do that with a single event case. When you murder somebody and you leave the scene of the crime, it's done. The statute of limitations is from the time of the murder of the single event, whatever it is, a car accident, a gunshot, a wound, a stabbing. There's no tolling in murder. I've never even heard of tolling or concealment being applied. Now, it's a separate crime if you kill somebody and then you bury them in a graveyard, and then the government starts to get close to the corpse, and then you go there at night, you dig that person up and you move them. That's a separate and distinct crime. That's different. That's not what happened here. What happened here is he's alleged to have, and I hate this guy. I think he's a monster, right? But I gotta defend the law on this one. There's no tolling by concealment in this case. It just it doesn't fit.
And just to make sure our viewers understand, for the first-degree murder and second-degree murder, there's not a statute of limitations. That's why we see these cases that are 30 years old and charges are brought against the person. But this is specific to voluntary manslaughter there in Tennessee. Eric Puryear, love to get your thoughts.
Yep, I'm going to have to agree completely here. The reality is murder is something that happens at a particular time, on a particular day. That's it. And I understand why the prosecution and the victim's family and a lot of people wish that there was some way to proceed there. But from what I'm seeing so far, I think the defense argument is correct. This statute of limitations has passed, and it's something where oftentimes a guilty person goes free, but when the law sets them free, that is still a positive thing for society as a whole, because we need to follow the law and be bound by the law and not just try to change the rules on each case to work what we think is the right outcome, because often that produces a worse injustice.
Wow, both of our experts agree that there's a possibility David Swift could walk out of jail a free man. This is the only charge remaining against him, this voluntary manslaughter. And if this judge decides that the statute of limitations expired on it, we could see a complete U-turn as far as the prosecution. We are going to squeeze in a break, get more of that hearing.
All right, let me bring in my guest for this hour. Joining us, national trial attorney, big case Michael Jaafar is with me. Mike, great to see you. Thank you so much for being with me this afternoon. First and foremost, just want to remind our viewers it's a preliminary hearing. Basically, it's a low standard. They have to show probable cause that the crime was committed way, way far away from beyond a reasonable doubt. But defense attorneys like it. And they like it because they get information. We're watching an attorney here doing exactly that, getting information.
Yeah, absolutely. These are very, 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 when you first become an attorney in Michigan, your first day of training to be a public defender is about the preliminary examination, which I don't know why others did. When I was a young attorney, I thought every state had it. I guess not many. It's a very important hearing, and here's why. It could cut both ways. Many attorneys actually waive these, and they don't conduct them, and here's why. Whatever you elicit during that preliminary examination, you're stuck with that trial. So the theory is, if he asks questions at this hearing and the person who answers them in a way where the attorney is not comfortable with, and that person, let's say, passes away before the trial, he's stuck with that testimony. And so it could cut both ways. It could cut in favor of you and against you. And if you notice, the defense did not bring any witness, right? They didn't bring any witness, and they wanted to examine the main person they wanted to examine was a deputy for the state, because they wanted to know what was a testing mechanism. Look, they only have one defense here. The defense, it's still a Hail Mary. Was the gabapentin in her system, and if it was, did that affect her legs and it prevent her from hitting the brakes? Because she clearly was driving in an assured distance. She was not passed out. And so were her legs affected? And so that attorney, Kolovas, I actually know him, he wanted to elicit whether or not the testing was done right, because the only defense they possibly have is the gabapentin in her system is what caused her to run into the boathouse and not the alcohol. One more thing, Michael, Michigan is one of the few states. The legislature got sick and tired of people blowing the 0.08 blood alcohol level, so they passed a super drunk law. If you're 0.17 or higher, it's a different crime. And so for her, I think she's cooked because she's at a 0.18. I don't think the gabapentin will be a reasonable argument, but it's the only one they've got.
Yeah, I mean, they have another one, which we'll get into coming up, where she apparently has seizures. And from the black box information that we know about, and we'll talk about that, like I said, coming up in the next block. But according to the black box information, she might have an argument that perhaps this was a seizure. We'll talk about what that might mean for the case and everything. But, Mike, I do have to take a break. Welcome back, folks. Before we head back to court, let me bring back in my guest, still with us, national trial attorney, actually based in Detroit, Michigan, Michael Jaafar. Mike, I want to get back to our discussion earlier. Again, second-degree murder in this case, any unplanned, non-premeditated, intentional killing of another caused by reckless disregard for human life. This goes back to what we were talking about earlier, this idea that maybe it was some combination of the gabapentin, which is meant to control any kind of seizures and things of that nature. And you're saying if she connects that or maybe that there's some mixture of alcohol. She claims she had one glass of wine at a bar, but of course the officer said he smelled a lot of alcohol, so I don't know if those jibe. But also, she claims that she might have had a seizure. Her legs stiffen up when she has a seizure. The black box showed that the speed from 5 seconds to impact, 5 seconds before, that whole time, the speed is increasing. And it shows that the gas pedal was pushed all the way down. That kind of plays into the idea that there was some sort of maybe seizure going on. Does that help her at all?
Yes, you stumbled right into the main point of this case. So had she not been drunk, I don't think she would have even been charged with murder too. I think she would have been charged with something else and she would have pled this out. But because of the fact that she was above a 0.17, she wasn't just above a 0.08, she was above a 0.17. You then fast forward to the fact that there's going to be a trial, there's going to be witnesses, there's going to be testimony, then there's going to be a closing argument. In the closing argument, I can tell you what the state's going to say because it's black letter law in Michigan. They're going to say at a 0.18, she no longer has the right to have any other, because even if she had a seizure and even if this murder was unintentional, by virtue of the fact of her making the intentional decision to get behind the wheel, even if she didn't have a seizure or did have a seizure, she made that overt decision. And by doing that, she created the situation where she could then have a seizure because we know that the seizure is exacerbated by alcohol, right? So she's not, the gabapentin in her system adds credibility to the fact that she had a seizure. And what you said right now that I didn't know, the forensic evidence also lends credibility to that. But the fact that she was super drunk, she's done.
Yeah, there's that reckless behavior, that reckless disregard for human life. All right, Mike, stand by. That fatal crash, of course, did kill two siblings, 4-year-old Zane and 8-year-old Alana Phillips.